All right, everybody, welcome to another episode of The Compliance Guy. I'm Sean Weiss, and as always, I want to start by saying thank you all so much for tuning in, logging on, and just hanging out with me for a little while as I get to spend time with some of the most interesting and some of the most critical people in our industry. When I say critical, I'm talking about their level of importance. Today, for me, this is a special treat because this is an individual who I had an opportunity to meet decades ago. And he's probably not going to be thrilled to hear that I'm talking about decades that I've known him. But the truth is, it's been that long. This dates back to the very early part of 1990. I refer to him as the Godfather. And when I say that, I'm sincere because this is really the godfather of corporate governance and compliance. And today I get to sit down with Gabriel Imperato of Nelson Mullins to discuss the False Claims Act. We're going to talk about regulatory compliance matters and what healthcare professionals need to be aware of to avoid unwanted legal entanglements. As the Deputy Chief Counsel for the Office of General Counsel at the United States Department of Health and Human Services out of Dallas, Texas, Gabriel advised and represented various agencies on the department and Health and Human Services, including the Centers for Medicare and Medicaid Services, the Public Health Service, the Social Security Administration, and the Office of the Inspector General. Gabriel's personal practice includes representing individuals and organizations accused of healthcare fraud and assisting and advising healthcare organizations on corporate governance and compliance matters. For me, I got to reconnect with Gabe through HCCA, and we're going to talk a little bit about this organization as we get into our conversation. But he is board certified as a specialist in health law by the Florida Bar. He is a graduate of DePaul University College of Law and the University of Massachusetts, so he is a wicked smat guy. Again, he holds his CHC through the Healthcare Compliance Organization, which is the Society of Corporate Compliance and Ethics and Healthcare Compliance Association. Again, this national accreditation reflects a professional level of competence and expertise in compliance processes sufficient to assist healthcare business organizations to understand and address legal obligations to promote organizational governance and integrity through the operation of effective compliance programs. Gabe really specializes in federal government strategies, healthcare compliance and operations, healthcare government investigations and litigation, healthcare QTAM investigations and litigation, state and local government. Listen, I could go on and on and on about how incredible of a healthcare professional and attorney Gabe is, but I want you all to get an opportunity to experience Gabe as I know him, as an incredible human being and somebody who has so much that he's given to this industry and so much that he continues to share with all of us that are lucky enough to be in his presence. So with that said, Gabe, welcome to the program. Thank you so much for carving out some time to be with me today. I know you've got an incredibly crazy, busy schedule, but this just means the world to me because, as I said, you know, you were one of the people who actually taught me law when you were at Nova Southeastern for a period of time. I've gotten a chance to work with you, as well as other incredible members that were partners of yours, Lester Peerling, and Brannon, Saul Weisenberg. So really a lot of ties, but all of my ties to those folks really stem from getting to know and work with you back in the early 90s. So thanks so much for being here.
Oh, I appreciate it, Sean. Thanks so much for your introduction. I don't know if I'm the godfather of anything, but I guess if you stick around long enough, you absorb something, and I'm happy to be here and spend time with your listeners to share whatever I can about the topic. So I'm never busy enough not to do that.
Well, I appreciate that. And as I said, I really got to know you when I was in South Florida and I was the administrator for a large multi-specialty organization. And, one of the questions that I want to really start off with, because I want people to kind of understand how you got to the point in this industry that you are, because you really are a giant in the world of healthcare compliance. I don't think there's anybody that is a member of HCCA or that, functions in the role of compliance who hasn't at least heard your name or read one of your articles. But the question that I have for you is, with so many areas of law, what drove you to healthcare and really specifically fraud, waste, and abuse?
Well, that's a good question. Uh, when I teach a class at Nova Law School, the professor of that class, Jerry Morris, always makes me sort of share with the students how I got into this field, and I'm happy to do that. So I graduated from UMass in Amherst in 1973. I was a political science major. But before I graduated, maybe my second semester, second year at UMass, I wasn't sure that I wanted to do what you could do when you had a political science degree. And this crusty old former reporter from the Chicago Sun-Times was hired by UMass to be a professor in the English department, and he offered a journalism course. They didn't have a school of journalism. They had an English department, and he offered a journalism course, and me and about 5 or 6 other students took it, and he taught me how to write a newspaper article. And from there, I took some other courses, and then we had a daily paper at UMass, and I started working on the paper. So by the time I graduated, I actually had enough experience, and I was qualified to become like a cub reporter. I moved back to New Jersey. I got a part-time job on my local weekly newspaper in my hometown. After a couple of months, that evolved into a full-time job at a daily newspaper. And I was a newspaper reporter for close to 2 years, covering politics, city council, the courts, law matters. And at a certain point, I decided, well, maybe I'll go to law school, and it might be a good idea to get a law background, even if I came back to journalism. So I didn't really go to law school to become a lawyer. I didn't have, I want to become a lawyer, So I went to law school, and but I did think if I do get a job as a lawyer, I might like to start with a federal government agency, which in some ways dictated why I went to school in Chicago, because I applied to schools that were in federal regional cities, okay, where they had all the agencies there. So first year law school, beginning of second semester law school, I saw an ad on the bulletin board in the law school for a law clerk's position at the Regional Office of Counsel for the U.S. Department of Health and Human Services. And I was like, maybe I'll apply for that. That's a federal agency. That sounds like something I might be interested in. I applied for the position. I was hired as a law clerk, started working 15, 20 hours a week, preparing briefs to defend agency decisions in federal court in the Midwest. One thing led to another, and one day I was in the room where they kept all the law students, and this strange fellow walked in who I didn't recognize as somebody who worked in the office, but I kind of suspected he might have been from the main office in DC. And turns out he was the Deputy General Counsel of the Department of Health and Human Services. So, not looking a gift horse in the mouth, I said, hey, I'd like to apply for a job here as a lawyer. And that triggered an event where he kind of went back to the local regional counsel and said, oh, you got a law clerk there who wants to apply for a job. and that kind of set off a chain reaction that resulted in me getting offered a job. And so I started working as an assistant regional attorney in the General Counsel's office of the Department of Health and Human Services. And my clients were what today is called CMS, the Office of Inspector General of HHS, Social Security Administration, Public Health Service, Food and Drug Administration, all those constituent agencies in the department. So I spent 4 years in Chicago doing a lot of federal court cases, moved to the central office in DC and Baltimore for 5 or 6 years doing fairly high-level trial work around the country. And then I was just about ready to kind of leave the government and go into private practice, and they asked me to go down to Dallas and be deputy counsel in the Dallas region and kind of shore up their litigation expertise. And I did that for a couple of years until 1986 when I decided for a variety of reasons to leave government, and I moved to South Florida for a combination of professional and personal reasons that seemed to make sense at the time. And looking at it in the rearview mirror, they still make sense. They still make sense then, and they make sense now. So,
yeah.
And then I started developing a private practice. And as you mentioned, I am certified as a health lawyer by the Florida bar. There's only 2 states that do that. Florida was the first, and then Texas does it now. And I've done everything pretty much to some extent or another that a health lawyer would be asked to do. But by the mid-90s, because I had sort of a special expertise in what us lawyers call the healthcare fraud and abuse area, as the federal government effort in that area started to ratchet up, that started to occupy more and more of my personal time. I wasn't doing any more healthcare matters that didn't have something to do with enforcement and compliance and some type of litigation. And so now when people ask me, well, what do you do? Well, I represent individuals and organizations that are accused of healthcare fraud, whether it's criminal, civil, or an administrative proceeding. And I counsel healthcare organizations on managing that risk through corporate governance and compliance efforts, and how to make them effective in managing those risks. Sean, I can't hear you.
So that leads me to a question. As I'm listening to you talking about how the government ratcheted up their efforts on compliance and fraud, waste, and abuse back in the 90s, I want to kind of fast forward a little bit to where we are today. And my question is, do you believe we've entered into a new era in our industry, given the aggressiveness of government, their contractors, how the commercial payers are pursuing things?
Well, yes, but let me explain it this way. So there were 2 things that happened in the 90s that really impacted our environment. One was the federal government's direct efforts in the enforcement area. But maybe more importantly was the emergence of the False Claims Act in the healthcare industry. For those of you who don't know, the False Claims Act is a statute that's been on the books since the Civil War, in its modern form since the mid-'80s. And it was primarily applied in the defense industry in the 80s and early 90s. It has a provision in it which is known as the whistleblower provision, which enables any individual who has direct or independent knowledge of the submission of false claims to the government can basically file a complaint and bring that information to the U.S. attorney in the federal scheme of things, to the Department of Justice, and advise them that they believe that the false claims are being submitted by a named defendant. Now, the procedure in that kind of case is you file the complaint, it's sealed by the clerk of the court, It's served on the Department of Justice, but it's not served on the defendant. And it's handled that way because the idea is to give the Department of Justice a period of time to investigate the allegations that the whistleblower is bringing to the table and to decide whether or not the Department of Justice wants to intervene and take over the case or decline to do that, in which case the whistleblower and his or her attorney has the option of pursuing the case on their own.
So as you said, this law has been around since the Civil War era, right? It was originally referred to as the Lincoln Law. And it was created obviously to combat defense contractors from ripping off the government, right? From charging them $250 for a toilet seat or something.
Yep.
The question that I have is, how did it really matriculate or grow into what it is today, specifically in the healthcare industry? Why is the False Claims Act such? I think it actually now took over as the industry that dominates the number of FCA cases that take place every year. How did that happen?
Well, okay. First of all, you're correct. I would say 80% of False Claims Act cases are in healthcare and are brought by whistleblowers. Okay. So how did it happen? Well, it was pretty simple. I'm not sure why it didn't happen sooner than this, but in 1994, a settlement was announced in the Southern District of California involving a whistleblower who blew the whistle on a competitor national clinical lab and their practices in selling a panel of tests to physicians and breaking off part of those tests for separate reimbursement without really saying that that was going to occur. And the case settled for $116 million, and the whistleblower received $13 million out of that for their trouble, plus attorney's fees.
Right.
Well, once that information was disseminated, the number of cases in healthcare started to go up. And by 1998, I think there were 500 plus cases filed under the False Claims Act, most of them whistleblower cases, most of them in the healthcare industry. Today, even with the pandemic, the Department of Justice still averages about 650 to 700 new cases a year. And none of these cases, are small cases. Right. And something that I want your listeners to understand, because this is where the risk is, where the rub of the risk is. If a whistleblower files a complaint and makes allegations, the Department of Justice must investigate that complaint. They can't just throw it away because they have to investigate it to a point where the U.S. attorney has to sort of prepare a memo to justify to a supervisor why we're doing what we're doing with the case, even if they decline to intervene and decide it has no merit. Right. That process typically takes 1 to 2 years. The cost associated with that is in the hundreds of thousands of dollars that the defendant never gets back. Okay. But it can be initiated, and you can be on that journey simply if a whistleblower goes to the right attorney and files a case. All right.
Got it.
One more point on that.
Yeah,
Sean.
please.
Originally, in healthcare, there were probably a dozen attorneys around the country who I would say were experienced whistleblower attorneys, but knew the healthcare industry. And they were the ones primarily bringing cases early on. But later, the rest of the plaintiff's bar realized that there was no cap on damages in this area, like there was in MedMal, which they were getting pushed out of. And they could migrate over to here and make a lot of money. So we started to see attorneys representing whistleblowers who weren't the usual people I knew, who actually knew something about the nuances of the healthcare industry. These were plaintiffs' attorneys who cut their teeth in the personal injury, med mal area, maybe. I kind of call them ham and eggers, okay? And they're just trolling for clients, whistleblowers,
Right.
to bring cases. And what we started to see happen, and we still see it today, the whistleblower might come in and say, well, so-and-so medical practice is routinely waiving coinsurances. Okay. And it violates federal law. Now, the attorney might not know what the whistleblower is really talking about.
Right.
But they can go to the Taxpayers Against Fraud organization, which is the organization that represents the interest of the whistleblower and whistleblower attorneys, and effectively, by the way.
They do.
And they can go there and say, hey, I got this whistleblower who's mumbling something about routine waiver of coinsurance. Do you got a complaint you can give me? From the library. And then you see a complaint gets filed that really doesn't have much traction to it. It has kind of canned sort of allegations, and off we go. So it's kind of as simple as that to get the party started. And once the party starts, your client has already suffered the damage.
Absolutely. And you and I share a mutual friend, Jacqueline DeMar, who is counsel at TAF, which is Taxpayers Against Fraud Educational Fund. She was on the program a few weeks back, gave a tremendous amount of information, really a lot of fun to collaborate with and work with. I got a chance to watch both you and Jacqueline out in Arizona on a panel that you all were doing together. I think Mike Trice was on there with you as well.
Oh, at the Healthcare Compliance Institute. Yep.
That's right. Yeah, it was a fascinating conversation. But since we're on the topic of the False Claims Act, let me ask this question. Is there a criminal aspect of the FCA? Because you always hear it as a civil law. Is there a criminal aspect to the FCA?
Yeah, yes is the short answer, but let me give you the more nuanced answer. So you can be liable under the Civil False Claims Act for knowing conduct. All right. But knowing or knowingly has a special definition in that statute. And the definition says that knowingly certainly includes conduct that you intentionally take, that you're taking and undertaking intentionally. But it also includes conduct that results in improper claims to the government as a result of deliberate ignorance or reckless disregard, which simply means claims going to the government because you stuck your head in the sand like an ostrich.
There you go.
All right. Now, deliberate ignorance, reckless disregard typically does not involve conduct that you could describe as knowing in the traditional sense that would make sense in a criminal case. All right. But knowing conduct in the traditional sense, which also is actionable under the Civil False Claims Act, can at the same time be examined to see if this conduct may form the basis for a criminal investigation.
Got it.
So, in fact, what occurs as a matter of procedure and policy at the Department of Justice is all civil whistleblower cases are screened by the criminal division for them to decide if they think the conduct alleged is outrageous enough, or for whatever other reason they want to enforce criminally. So the whistleblowers get driven in by the tremendous recoveries that can be made. And the information comes in with them and gets shared over on the criminal side of our enforcement agencies. And they decide, okay, this may be a good case for criminal. And that's in fact how it's occurred for now 25 years. So
Got it. Yeah, I had Jose Vela Jr. On the program, gosh, months and months ago. And one of the things that I thought was so interesting that we were talking about, he said, "Hey, Sean, listen, 85% of the cases that I had in the civil, unit, 85% of those were referred on for criminal prosecution." He said the number is tremendous, which leads me to another question. So, we see a lot of cases being brought under the False Claims Act statute, right? But they're being linked to the anti-kickback statutes or to Stark. Why are those part of an FCA case?
Well, so in the late 90s, there were cases brought under the following theory. The referral of this patient for services violated the kickback statute or the Stark law. And even though the services were provided, were legitimate, medically necessary, and properly billed and claimed appropriately, the claim was tainted by the original violation of the kickback statute and or the Stark law.
Got it.
We call it the tainted claim theory. In the late 90s and early 2000s, the case law did not universally accept that theory, all right? When Attorney General Ashcroft was appointed during the Bush administration in 2000, Senator Grassley, as a condition of consent of the Senate, made him obligate himself to establish that theory of liability under the False Claims Act through the development of case law, okay? In other words, DOJ was going to take that position and find cases to put forth that position and develop the precedent, to make it happen.
Right.
And that didn't turn out to be too heavy a lift. The courts ultimately accepted that because I think just from a common sense standpoint, no one could really condone a legitimate claim that was the result of a kickback. Okay. The government would tell you that's a material deficiency in the claim, and it will follow a case to the claim. The Stark law, same dynamic. Now, the materiality of those deficiencies may start to fray if the allegation is, well, you failed to comply with the Clinical Lab Improvement Act provision about X, Y, and Z, and therefore any claims that were submitted were false. Well, the courts were starting to say, well, I'm not sure that deficiency is materially enough to be a precedent for False Claims Act liability. But a kickback violation and or a Stark violation definitely is.
So on that same note, and I have just a couple of other questions for you before we switch gears.
Okay.
Are there any other charges or allegations that you're seeing prosecutors attaching to FCA cases or to healthcare fraud statute cases?
Well, yeah, I will say this, that you have the kickback and Stark tainted claim theory cases, and there's a lot of those. All right. You have what I call standard false claims cases, upcoding, and then more and more lately, medical necessity cases. And we see physicians becoming whistleblowers more and more these days, and not unwilling to rat out their colleagues who are doing improper procedures. For example, I remember a case not too long ago that settled down here in South Florida, and I think 2 physicians at a local hospital were the whistleblowers, and the defendant was another physician at that hospital. And the allegation was that this physician would run a patient through a standard battery of diagnostic tests, whether they came into the office or to the hospital physician practice with a hangnail or cancer. And they'd get the same battery of diagnostic tests. And with no link to real medical necessity or reasonableness.
Right.
In that case ended up settling for $12 million. So we see a lot of that. What I call your classic false claims theory, duplicate claims. We are seeing a lot of this failure to collect coinsurance. That's been out there more than I'd like to admit.
Right.
And clinical trial, clinical laboratory compliance stuff is out there too. But a lot of it is not so much different than what we saw 20, 25 years ago. It's like it's repeating a cycle type of thing.
Yeah, I agree with you. I feel like a lot of the things that I saw 25 years ago, 28 years ago, when I really first started getting into the kind of work that I do now, we're starting to see these cycles repeat themselves. But that leads me to a question, because we've talked a lot about relayers. Mm-hmm. And I guess one of the last questions that I have for you on this topic is, what does it mean to have actual knowledge as a relayer? And the second part of that is, why are we seeing so many attorneys bringing QTAM suits on their own?
You mean as relators?
As relators.
Oh, okay. Well, all right. So let me go to your first question.
Yeah.
Well, all right. So under federal law, the False Claims Act and the Federal Rules of Procedure, when you allege fraud, you're required to allege it with sufficient particularity so that the defendant can be on notice as to what exactly you're alleging is the fraudulent conduct. In the False Claims Act space, that becomes a test early on in the case. And a defendant will typically file what they call a motion to dismiss under Rule 9b to test the sufficiency of the complaint to plead fraud with particularity. What that turns out to mean as a practical matter for a whistleblower and his or her attorney is that you have to identify the who, what, where, why, and when of the claims that you're alleging were submitted are false or fraudulent. Or if you can't do exactly that, then you have to have been in a position, or there must be some other collateral indication that the allegations you're making are reliable.
Got it.
So let's say you're the supervisor of billing in a medical practice or in a hospital, and you're making allegations about, upcoding or false claims. You're probably going to be able to pass the 9B test based on your position in the organization and access to information, even if you can't tell exactly about the who, what, where, why, and when of the claims you're talking about. As a matter of practice, relators attorneys try to identify in their complaint the who, what, where, why, and when of claims, because they know that'll pass the test. But right. Barring that, here's some other reasons why this whistleblower's allegations are reliable and have the indicia of reliability. Got it.
So, and then the second part of that, so I've seen, obviously outside of doing my podcast, I serve as an expert in federal, civil, and criminal matters, administrative matters, for law firms across the country, including for Nelson Mullins with some of your partners.
Right.
And one of the things that I've been brought into recently are cases being brought by attorneys
Yeah.
acting as the relator themselves
Yeah.
because they're utilizing open source data, or they're using information that's been released, by the Centers for Medicare and Medicaid Services to, that point to providers' income, as far as revenue generation, their volume, etc. Why is it that these attorneys are able to file these whistleblower or QTAM claims on their own?
Well, that makes me think of a case I settled several years ago where the relator was like a CPA type, and he was a patient of one of our clients, a physician. And his complaint, as it turned out, was primarily based on data he obtained from the public record from CMS about our client's procedures and the frequency of those procedures. And now, when you say attorneys as relators, I can't say that I've seen that often, but where I have seen it, there are significant risks for attorneys being relators because of attorney-client privilege. And there was one fairly well-reported case about 3 or 4 years ago, maybe longer, in New York, where one of the relators, there were a couple of relators, but one of them was an attorney, and it was an attorney for the defendant organization in the past. And the court threw that plaintiff out, basically saying, there's too much risk here that you're going to proceed against this defendant based on what otherwise is privileged information, and you shouldn't be in this space. So I, if a client came to me who was an attorney, acting as an attorney, I don't mean who's a compliance officer who happens to have a law degree.
Right.
I would be cautious about taking that case because I'd be concerned that it would be thrown out pretty early.
Yeah, I think that's a great point. And there's an inherent difference between a practicing attorney and someone serving as a corporate compliance officer with a law degree at a health system. Very, very different. So you brought up a term that I love to talk about, and it's data analytics, right?
Uh-huh.
So a question that I have for you is, how important is it, and why is it so important for practices to run analytics on their providers and their practice?
Well, because I don't know how else that they're going to be able to know what the utilization and claims practices are of those providers. I mean, in your typical medical practice, it's not like there's, you're not supervising physicians day to day, but the organization is responsible for making sure that the claims are legitimate claims that are not false or fraudulent,
Right,
or not going out the door out of deliberate ignorance or reckless disregard, or sticking their head in the sand. So you have to have a monitoring or auditing facility to kind of review these claims and the practices in the utilization, and to identify any aberrancies that would suggest non-compliant activity so that you can remediate it.
gotcha. So you brought up another term. See, this is why I love talking to you, because you stimulate the mind to be able to go in so many different directions. So you brought up auditing and monitoring, right? Which is a key element, right? It's one of the 7 key elements of a corporate compliance program. What a lot of folks are not aware of is that since 2010, it has been a requirement that any physician providing services to Medicare or Medicaid beneficiaries has to have a corporate compliance program in place. That's under ACA. But yet we've seen little enforcement when it comes to making sure that providers have compliance programs. Absent the lack of enforcement, why is it so critical for a practice to have a corporate compliance program, and what does it mean to be an effective program?
Well, all right. First, why is it important to have a compliance program? Because that's the only way that an organization can manage this risk of False Claims Act liability and the risk that your next employee is going to be a whistleblower and take you on the expensive journey with the potential for reputational damage and a lot of other stuff. Okay. So your only real way to manage that risk is to have an effective compliance program. And so what is an effective compliance program? Well, the kinds of things that alert someone to the effectiveness of a compliance program are: one, what does your reporting log look like? What's the volume of reports? What's the nature of the reports? And from volume and nature of reports, you can tell pretty quick if you have the attention of your constituents to report non-compliant activity internally. Because if they do that, they're not reporting it externally. If they feel like they can report it internally, they're not reporting it externally. And that gives the organization a chance to deal with it, okay? So that's one indicia of an effective program. Another one is a lack of hesitation to report by your employees because they're not afraid of being retaliated against. A good anti-retaliation culture. And, you know, I've always been a little schizophrenic about the retaliation risk because I've seen how individuals have abused that liability for, you know, fun and profit. But it's a very important concept for compliance professionals because if their organization does not have some degree of an anti-retaliation culture, they're never going to learn of the situations and activity that is putting the organization at risk, and they're never going to get a chance to deal with it until it's too late and you got the Department of Justice in the driver's seat with you. Okay. The ability to investigate reports of non-compliant activity. That's a real key to an effective compliance program. And I'll tell you that there was a time where I probably didn't fully appreciate the value of being able to conduct an effective internal investigation. But I've come to learn over the years, there's no substitute for the facts in these situations. It can resolve 75% of what looks like a tsunami when you get the first report, but turns out to be, you know, a trickle when you finally learn what the facts are. And then, of course, discipline for not participating or supporting the compliance program, incentives for doing what they expect you to do. It's really the compliance program that is your key to managing risk. And an effective one is what manages that risk.
So basically, it's got to be a living, breathing document. It's not just a paperweight that sits on your desk or something that sits on a bookshelf and collects dust. This is something that has to be a culture within your organization.
Yeah, it's a heavy lift,
Right.
no matter what. Okay. It reminds me of this situation recently where, you know, we had to ask some compliance professionals to come in and act as an interim compliance officer and a compliance expert to get a compliance program off the ground for this organization because they needed to do that for a lot of reasons, not the least of which was you're really smack dab in the middle of this industry and you're just an accident waiting to happen. Well, you're an accident that's already happened. Right. You're just waiting for it to happen again unless you have an effective compliance program. And, you know, we got top people to go in there to start the ball rolling. And, guess what? They got to be there every day, 9 to 5, 9 to 6, walking the walk, talking the talk, getting that organization turned around, making sure everybody knows what their responsibility is for compliance, putting in the processes in place to create an effective program. And it's no small task.
No, it's not. I've been very blessed over this career to serve as a corporate compliance officer for some of the nation's largest health systems. I've been very blessed to be brought in situations like what you were just talking about, where a law firm has a client that is in need of, creating and implementing and monitoring a corporate compliance program. And you're right, it's no small feat. It is a heavy lift. It is a lot of work, and it's something that has to become a part of the fabric of the organization in order for it to really work. And it has to be a top
I
down.
heard somebody say once that everybody in the organization is responsible for compliance.
Yeah.
And I think if you have an effective compliance program, your employees know that eventually, to some degree or another. But
I think that's a great point. All right. So I've consumed a lot of your time. One of the things that I always love to ask all of our guests at the end of each program is whether you have any key takeaways for our listeners, because you've given so many great nuggets of information. You've given such great examples throughout this podcast that we've been doing now for about 45 minutes. Any final takeaways, any final thoughts that you have that, practices should be doing, or things that they should be avoiding in order to, avoid that possible legal entanglement?
all right, so let me start with things that you should govern your day-to-day. A healthcare organization ignores reports of non-compliant activity in today's environment at significant risk. So if you get a report anonymously on your hotline, or some squeaky wheel walks into your office and makes a report, or somebody makes a report that you couldn't imagine could be substantiated, you have to respond to all of those. Even if the response turns out to be, I looked into it to a certain extent and concluded that there was no there because, and I closed the file. But there's a memo in the file that says why you closed the file, okay? You cannot ignore any report of, and don't react to the reporter. Right. React to the report, okay? You may hate the reporter. You may know the reporter is lying, but you gotta go and rebut or substantiate the report, one way or the other. I mean, that's one takeaway. Another takeaway. Compliance issues in organizations, sometimes they're fairly routine and can be dealt with, but other times things come up that you should probably not address without the guidance of someone with experience in dealing with those things. And then especially if the incident involves a repayment obligation associated with certain misconduct that the organization should consider self-disclosing to get a release from that liability. My recommendation on that, one, you should get experienced counsel or consultant to examine the conduct that you're looking at to get a realistic assessment of what level of liability it represents, and then to discuss the pros and cons of maybe a self-disclosure to try to get a release from that liability, and then getting experienced and competent counsel to help you walk through that self-disclosure journey, because there's no book for that.
Right.
It's really, how many self-disclosures have you done? 100. All right. So the journey. All right. Well, I haven't done any, but I used to be an assistant U.S. attorney. You need somebody who's walked the walk there. Okay. So.
All right. So I know you give a lot of lectures. I know you're part of a lot of big events going on. Anything coming down the pike that you're going to be presenting at, or you're going to be a part of? Anything that you want any of our listeners to know about any upcoming events?
Yeah, so let me make a shameless plug for the American Bar Association Annual Health Fraud Institute. I've been the program chairman for this program for over 25 years. This is the first time we're going back out live in 3 years in Las Vegas, starting on Wednesday, the 22nd through Friday, the 24th. I will guarantee anybody that attends that you will notice very quickly that the topics are well selected and timely and relevant, that the speakers are very experienced, and that you will learn a lot from the interaction, the networking, and the education that is rolled out during the institute. It's for government enforcement lawyers and investigators, for defense counsel, for consultants, for compliance professionals, for relators counsel, and we all get tuned up for about 2 full days on a variety of topics and interactions, and it really is, I think, the best educational program for that particular space that I'm aware of in the United States. So,
well, I hope they're recording some of these sessions, if not all of the sessions, for somebody like myself.
they are
good, because I am absolutely going to be purchasing those. Unfortunately, I'm not able to make it out there to Vegas this year because I'm going to be in Texas on an investigation. But I'm excited that y'all are going to be recording these sessions, and I'll make sure that I can get the information for all of our listeners from you, Gabriel, once it's available on a link to where they can go to get access to all of these recorded sessions. I want to say thank you so much to Gabriel Imperato of Nelson Mullins for taking time out of what can only be explained as a crazy work schedule to spend some time with me and all of our listeners to share in his experience, his knowledge, and to provide recommendations that can be deployed in your practice immediately. Gabe, thanks so much for being here today. It's really been an honor and a pleasure to get to hang out with you for a little while.
Well, same here, Sean. I really appreciate the opportunity, and thanks to all listeners for sticking around for an hour and hearing what we have to say.
Absolutely. And I hope that you'll consider coming back on the program again sometime in the future. We always will leave the door open for you.
Oh, happy to.
Okay. All right. So that's going to bring us to the end of this episode with Gabriel Imperato, partner at Nelson Mullins, the Godfather, as I like to refer to him, of corporate governance and regulatory compliance. And to each and every single one of you who tunes in, logs on, and hangs out with us each and every single day, whether it's the Daily Dose, whether it's the Compliance Roundtable, or our Thursday episodes with our special guests, or our hashtag Terry Tuesdays with Terry Fletcher. Thank you all so much for being a part of this each and every single day. Thank you so much for making us number 7 on the top 25 health, law, and regulatory compliance podcasts here in the United States. Remember, be good to yourself, but more importantly, be good to each other. And until next time,